Good morning, everyone. So great to see you all here. My name is Professor Margaret Russell, or Margaret Russell, and in addition to being a member of the Constitutional Law faculty here for many years, I am also the Associate Provost for Diversity and Inclusion, and I would like to thank everyone who has worked on this program. It has honored us to be a location for this event today, and for me to witness and work with people planning it. And I want to welcome all of you to our law school, which is still a pretty new law school. It's a 2-year-old building, but we're over 100 years old as a law school, and we were across the way in some older buildings that have already faded from my memory. I am also pleased and honored, actually, today to have Judge Roberta Hayashi, who spearheaded this incredible project with many people over a long period of time. And so she will explain basically the lineup of the program.
Thank you, Professor Russell, and thank you all for being here. This project started almost 5 years ago when I was sworn in as a judge on Fred Korematsu's Day of Civil Liberties in the Constitution. And I selected that day because I had long admired the work that Fred Korematsu had done as a civil rights advocate, and that work is being continued through the Korematsu Institute. My friend Aggie Itamoto, who was then the executive director for the Japanese-American Museum of San Jose, and was at my investiture, and I said, you know, we need to do this in perpetuity, or at least for a while, because not enough people know about Fred Korematsu, know about his work, and there is a need for people to not forget the lessons that came out from the incarceration of Japanese Americans during World War II and the response by the courts over the years to that action. So Aggie and I started a group, and we were very pleased to be joined over the years, and almost instantly, by Asian Law Alliance, by the Council for American-Islamic Relations, and most importantly to me, by the Superior Court of this county through the Community Outreach Committee. And I just want to recognize some people who are here. In addition to the justices and judges who are going to be on your panel today, Justice Mary Greenwood of the 6th District Court of Appeals, who you'll be hearing more from, Judges Drew Takeichi and Johnny Gogo, and by the way, Judge Gogo is the latest member of our bench. Judge Cynthia Lee is here, also from our bench. Trying to see. And of course, you'll be hearing later from Karen Korematsu, Executive Director for the Korematsu Institute, and our host today, Professor Margaret Russell, as part of the program. You will also, I hope, have had the opportunity to see the 9th Circuit exhibit about the incarceration out in the lobby. If you didn't have time to do that before the program, please take the time to go through that. It's an incredible historical exhibit. And also talk with the wonderful folks for the Council of American-Islamic Relations and the work that they are doing in our community to fight discrimination and bias, particularly against Muslim Americans, which is something that Fred Korematsu worked very hard to do in his life in the wake of 9/11. I also want to mention a couple things in particular. First, we will be doing, our program for today is that we're going to be showing the film of Civil Wrongs and Rights, the Fred Korematsu story. This is a 24-minute version of the documentary, but the Korematsu Institute has graciously provided the 55-minute version of the documentary, which will be shown this weekend at the museum. And we hope you'll visit the museum, because anybody who's attending today, if you didn't stop by the registration table, anybody who stops by there today will pick up a free admission pass to the Japanese American Museum for this afternoon or for tomorrow. It's a wonderful museum located in San Jose, Japantown, about a 5-minute drive from there. It's surrounded by some really good restaurants. So if, you know, after this muffin today, you feel like you need something a little more substantial, I would encourage you to go over to the museum. They have exhibits that trace the history of Japanese Americans, not only in our county, but also in the state of California. And they have provided those free admission passes, and through the Korematsu Institute, the opportunity to see the full-length version of the documentary. Second item I wanted to mention is that on Thursday, January 30th, which is Korematsu, Day of Civil Liberties and the Constitution, the Santa Clara County Superior Court will be having a second event at the noon hour. Dale Manami, who you'll see in the film, is going to be speaking, and we will also be showing the 55-minute version of the film at that time. Also on Korematsu Day, Dale Manami, Professor Russell, some other folks are going to be speaking back here at the law school in the evening. So I want to let you know this has really been a community effort to provide some additional information and education about Fred Korematsu and about the fight against discrimination and bias. By the way, hopefully you all saw the one-page sheet, received a copy of it, and saw the list of all of our co-sponsoring organizations. The schedule for today is after the showing of the film. We will have a mock trial. I want to specifically recognize Chris Vu and Eric Perez, who are our 2 Santa Clara law students, who are taking in this case. But their work was supported through the writing of a bench memorandum for our justices today. This bench memorandum and brief bore the contributions not only of Mr. Vu and Mr. Perez, but also of law students Ian Whitehead, Elise Tran, Diana Hahn, Jasper Hall, and who could not be with us, and Kirby Nguyen, who could not be with us today because of other commitments related to their being active law students, but were able to really add to the development of this brief and this project. So I want to thank and recognize them all. The full memorandum bench memorandum, which includes the legal arguments, will be available online. So Professor Russell is going to spearhead making sure that that gets posted to the SCU EDU website. And so we will make that available to all of you if you want to log into that website, or if you want to send an email to Benjamin Rada, and his contact information, I believe, is out there. It is. So Ben Rada's contact information is there. If you send him an email, we will make sure and get the link to you so that if you want to download the memorandum and briefs from today. Thank you. And with that note, let's roll the film, as they say.
We didn't expect the worst to happen. December 7th, it was Sunday. My girlfriend and I were up on Skyline Boulevard, looking down the Bay Area of the cities. At that time, I was going around with a Caucasian girlfriend. And we had spread out the Sunday magazine. It just realized and it had the music on, car radio, Sunday, nice sunny day. And of course, we were talking mush. And all of a sudden, it stopped. And they announced that Pearl Harbor was attacked. There's been so much friction between the United States and Japan, and the way Japan was so active, going into China and doing all that, invasion and so forth, that I had a feeling that they're just crazy enough to come down here, and that's what they did. my parents, they were all around the radio listening. They weren't saying very much. My mother was crying, my father was just disgusted. All that work that my parents did to the nursery and so forth, what's going to happen?
There were a lot of organizations that wanted internment, the agricultural interests in California, for example, because Japanese Americans had been so successful as farmers and competitors.
So when Pearl Harbor hit, now they could say it was, quote, military necessity, and therefore they could wholesalely exclude persons of Japanese ancestry from the West Coast. There were a lot of persons, agricultural persons, the media persons, who were whipping up anti-Japanese sentiments.
General DeWitt was lieutenant general, about as high as they get, was the general in charge of the West Coast. There was some feeling that the West Coast might be invaded. He had recommended that the Japanese Americans be excluded from the West Coast so that they couldn't give secret tips to the invaders if the invaders ever came. That was sheer baloney, because there is no instance ever discovered in which any Japanese American on the West Coast ever did anything disloyal. It was pure foolishness.
Colonel Van Detsen, who was a government lawyer, wrote all of the arguments for the internment that General DeWitt presented to the War Department. Van Detsen simply said that because Japanese Americans belonged to an enemy race, their internment could be justified.
See, before the war, my parents were very proud people. They always talked about Japan, you know, and also about the samurai and stuff like that. And run at the Pearl Harbor and just, you know, they were just real quiet. They kept it to themselves. They were afraid to talk about that.
The Secret Service and the FBI had swept into the Japanese American community and had arrested any community leader, any teacher, any civic organization head of any importance in that community.
I thought the exclusion order would be only for aliens and those that were born in Japan. I didn't think that the government would go as far as to include American citizens. Well, I know I couldn't take my girlfriend with me, so I decided maybe we should try to sneak out to Nevada to get away from this. And then one day my girlfriend wanted to meet me. I was waiting for her at the corner, and she didn't show up. I ran out of cigarettes. So, like a darn fool, I went across the street to the drugstore, and someone recognized me, I assumed, because when I came back and I was standing there for another 5 minutes, then the police came, and they looked around, and they looked at me and said, "Did you see any short Japanese person around here, Asian?" I said, "No." They looked at me and said, "Well, let me see your identification." By that time, the 2 MPs came in the military. And he says, "We have to take you to the city hall." After I was arrested, I never did see my girlfriend again. MPs took me to a separate room. It was a horse stall, and it was way out on the other side of the racetrack. And they took me there in a pickup. But it was a big door with horses in. There's a gap about 12 inches down below. There's no floor. It's just dirt. It's so the wind was blowing through there, and there's cracks all around the wall, and there was a light bulb up there, one light bulb in the ceiling, and that was it. And I went there and I lied on the cot and I said, gee, jail was a lot better than this.
After we got to Topaz, Utah, people realized who Fred was. He felt very lonely there at Topaz. He was working digging ditches, they were building a hospital, and the crew was very cold to him. Some people had this terrible feeling that Fred thought he was different than the rest of us Japanese Americans, and so they sort of shunned him.
I believe in principles. And certainly I believe that all persons, without distinction, are entitled to the support of the Constitution. We tried to find a legal challenge to the internment, but of course, in order to do that, you have to have a test case. You have to find somebody who is willing to have his case carried through the courts up to the U.S. Supreme Court. So we were on the lookout to find a case of that kind. It wasn't easy until I heard of Fred Korematsu's case.
The real significance of Fred's case is that it raised, for the first time, the central issue. Was the internment itself constitutional?
Our case depended on the U.S. Supreme Court. We recognized that at the outset because they would recognize there's no basis legally for this discrimination. It's a denial of due process of law.
It's part of the obligation of attorneys who present cases before the Supreme Court, and supremely so of government attorneys, the Solicitor General, that they have to be candid and honest with the court so that the Supreme Court can decide these matters of public policy on the basis of a well-developed record of all the relevant facts. And one of the tragedies of the Korematsu case was that that didn't happen.
The government had two basic arguments. One was that as a matter of military necessity, that is the prevention of espionage and sabotage, the evacuation was required. The other was that it was limited to Japanese Americans because their racial characteristics, what one of the government lawyers said, they belong to an enemy race, was a flat-out racist argument.
Race was not really an issue apart from slavery until the Civil War. Then we have the 14th Amendment, which guarantees to every citizen equal protection of the laws. But the court rapidly retreated from that jurisprudence so that by the 1890s, we have a case called Plessy versus Ferguson, which allows separate but equal, right? Separate but equal drinking fountains, separate but equal places on the bus. And that's the state of the law at the time of Korematsu. The country was rife with racial prejudice, and the Constitution did not do much to prevent it.
I think really the Supreme Court deserves to be criticized in these cases. You read the transcripts of the arguments, the justices are not saying, where's the evidence to support General DeWitt's charges? They're simply going along, and I think one reason for that is that some members of the court, I would say Justice Frankfurter in particular, felt that it was their patriotic duty to support the president in this case without regard to the Constitution.
Well, I think the Korematsu case illustrates a number of important things for our society. One is that the courts failed us at an important time and an important juncture, as did a number of our very great leaders, because after all it was President Roosevelt, who signed the executive order that interned the Japanese in California and throughout the western United States.
Over the years, this branch has handled at least 8 cases in the U.S. Supreme Courts. We lost one case. And the shocking thing is that we lost the case of racial discrimination against Japanese. That's a shocking thing.
I was dumbfounded what happened. But I continued on. I said, I'm an American, and it's as long as I'm in this country, that I'm going to keep on going. And if there's a chance of reopening the case, I will do it.
I met Fred after his Supreme Court case had been decided, and later we married and eventually moved to California to live.
When our daughter Karen was, I believe she was a junior in high school, she came home from one afternoon and said that in her social studies class, her friend Maya had given a report about the Japanese concentration camps, Japanese American concentration camps, and that they mentioned the Korematsu case, and she said, what is this all about? And I said, well, that's your father.
Well, you know, why did you never tell me about this? I mean, why wasn't anything ever talked about my father in this regard? I couldn't believe it. I was really upset. And she said basically that it was something that, it was a subject that my father chose not to discuss.
He was quite aware that he had a criminal record, and he did experience discrimination when he applied for employment.
He felt responsible for the internment in a sort of backhanded way because his case had been lost in the Supreme Court.
He always wanted to reopen his case, but we didn't know how to do that.
The internment of Japanese Americans was a fait accompli. By 1944, people had already lost their property, 110,000 people. Some were now homeless. Some had lost their lives. Their whole structure and community was now broken. At that point, do you admit the wrongdoing and say, we're sorry, or do you cover it up? And in 1944, they chose to cover it up.
It was the opportunity to go back and recreate history, a history that had a personal impact on my family, on a whole population of people, that had a major impact on the civil rights laws.
Korematsu versus the United States was a civil rights disaster. So to be able to reopen that case, to be able to vindicate our families, and to rewrite the books on this was a real opportunity.
What I did not expect to find was literally on the top of the first file, a document from one of the Justice Department lawyers to the Solicitor General of the United States saying, we are telling lies to the Supreme Court. We have an obligation to tell the truth to the court.
The lawyers on the legal team were mainly Japanese American. They're very young lawyers, very idealistic young attorneys. And the question was, if you're going to reopen these monumental Supreme Court cases, do you know what you're doing? And I think there was a sense in the community that these lawyers better not lose Korematsu versus the United States for a second time. The question was, how was the government going to refute these admissions of wrongdoing and cover-up and suppression being made by the government's own lawyers?
I really think they were adrift in the Department of Justice, and this is what we had heard. There were hawks and there were doves. There were people who wanted to just give in to the petition. There were people who wanted to fight the petition. As a result, they could not come to a coherent position. So, as they are wont to do at times of confusion, they just decided on a strategy of delay.
And after a period of 2 or 3 months with no response, the government then approached lead counsel Dale Minami and said, well, what about a pardon? Do you think Fred Korematsu would accept a pardon?
Well, of course, a pardon has a certain connotation to it, that you did something that was wrong, but your government is willing to forgive you for it.
And we brought it to Fred and Catherine, and her feeling was, it's Fred's position that the government should seek a pardon from him.
I concluded after looking at all of the facts that they had done something tantamount to confessing error. And when the government does in fact come in and confess error, even though they don't say in those magic incantation words, we confess error, they had done substantially the same thing.
When we went into the courtroom the next day, the judge outlined the posture of the case. I spoke Victor Stone spoke, Fred Korematsu spoke, and she rendered her decision then, all in one day.
We knew in advance that there was going to be a fairly large number of people in attendance, and so we did agree to open up the ceremonial courtroom, which was a much larger courtroom, and the place was packed.
A lot of these people had been in the camps. A lot of these people had not seen each other for 40 years. There was a lot of excitement in the courtroom.
Mr. Stone didn't want the court to make any kind of findings of fact, any kind of conclusions about what had happened some 40 years ago. So he pleaded to the court not to make any findings, that this is a case 40 years ago. Let's just let bygones be bygones. These wounds need healing.
And Dale Manami, when he addressed the court, said, well, whose feelings are we talking about? Are we talking about the wounds of Japanese Americans who've already been in prison, who've already suffered the losses, who've already suffered the indignity and the humiliation of being in prison? Or are we talking about the reputations of government authorities who, in essence, lied to the Supreme Court, as demonstrated by the government's own documents?
And after Dale finished, Fred made what I think was a very powerful, very simple, direct appeal. He said, 40 years ago, I came into this courtroom in handcuffs, and I was sent to a camp. He said, the camp was not fit for human habitation. Horse stalls are for horses, not for people.
And then went on to entreat the court to overturn his conviction, saying that what happened to him could happen to any American citizen who looks different or who comes from a different country, and that it was important for this court to understand that the relief given to him was not just for him personally, but for, in a sense, the benefit of the whole country.
And as soon as he'd ended, and as soon as the argument was over, Judge Patel made her ruling right from the bench.
I decided beforehand that the people had come for a reason, and they deserved some kind of a response from the court.
And she issued her ruling, in essence stating that there was sufficient evidence of governmental misconduct, of suppression of evidence, and that the policies of the American government were infected with racism.
And when she finished and just got up and left, walked out of the courtroom, the audience literally was stunned.
I turned to Fred, and Fred looked at me and said, what happened? And I said, Fred, you won. Your conviction's thrown out, you won. And Fred looked at me in a very subdued way. I think he was a little stunned, and he said, that's good. That's really good.
And I just couldn't believe it. It took me quite a while before I actually sunk in that I have won.
We understood when we first took this case that by attacking the conviction under the vehicle we were using, we could not overturn the actual Supreme Court ruling that was rendered in 1944. That was our greatest hope, but we could not find a legal vehicle to do so. So the Supreme Court precedent still stands as a legal precedent.
The principle that you can single out people on the basis of their race, their ancestry, I think is the principle that is so dangerous, so subversive to our Constitution.
It may help some people to go, wait a minute, what's going on in America right now? Are we inadvertently and in an unconscious way perpetrating a similar abuse against another group?
There was discussion that if any American prisoners were taken in the war, in Desert Storm, that there would be a roundup of Iraqis as a trade-off of POWs.
2 years ago, I spoke at the University of Michigan, and we were going through there with the group of us, and all of a sudden, there was another group, students came from the other end, about 15 of them, and they surrounded me and said, Fred, we appreciate what you've been doing. And they gave me a certificate, and it was the Arab students of Michigan.
Today, Fred Korematsu is seen as a hero, as he should be.
Fred was the ordinary person who at a time of great crisis rises to extraordinary heights.
Fred reminded me very much of somebody else, and that's Rosa Parks, the woman who refused to sit in the back of a bus in Birmingham, Alabama. And it's ordinary people like that just making a stand. And it's usually something very simple, like going to work. Fred wanted to stay in his home. That's all he wanted to do. And it's the right that every American has. But it's that kind of person, ordinary people who do extraordinary things, that really shape our history.
In the long history of our country's constant search for justice, some names of ordinary citizens stand for millions of souls. Plessy, Brown, Parks. To that distinguished list, today we add the name of Fred Korematsu.
Ladies and gentlemen, at this time we're doing a mock trial in the Court of History. The Court of History doesn't really exist, except it's been mentioned a couple times, as you'll hear in a moment. I'm going to play the role of the court's research attorney, and as Justice Greenwood could confirm, before an oral argument takes place in a court of appeals, what happens is that the justices have a conference at which they are briefed about the arguments that they may expect to hear. They've been provided with copies of the briefs written by the attorneys. They have had the opportunity to have their research attorneys review those briefs and write memos for them, bench memos. In this case, the bench memo that's been written was written by our law students that I mentioned earlier, and they went through and briefed the arguments. So now I, as the legal research attorney for the court, am going to talk briefly with the justices and normally this conference would take place probably in the justices' chambers, not on the bench. But for purposes of logistics today and to make sure that everybody can hear this, I'm going to be addressing them from the podium, and we'll then turn around the podium and the attorneys will provide legal argument. After the legal argument, the justices are going to meet, again, presumably back in chambers, but here on the bench so that you can hear their discussion of how they would decide the case. So, good morning, Justices. This is a case of Fred Korematsu on behalf of himself and 120,000 Japanese Americans versus the United States of America in the Court of History. The Court of History has been invoked a couple of times in this case. Judge Patel, in her decision on the writ of coram nobis, wrote that Korematsu remains on the pages of our legal and political history as a legal precedent is now recognized as having very limited application. As historical precedent, it's a constant caution that in times of war or declared military necessity, our institutions must be vigilant in protecting constitutional guarantees. It stands as a caution that in times of distress, the shield of military necessity and national security must not be used to protect governmental actions from close scrutiny and accountability. It stands as a caution that in times of international hostility and antagonisms, our institutions, legislative, executive, and judicial, must be prepared to exercise their authority to protect all citizens from the petty fears and prejudices that are so easily aroused. In Trump versus Hawaii, which was just handed down by the U.S. Supreme Court in 2018, a 5-4 majority of the Supreme Court said that you, the court of history, have essentially overruled Korematsu versus United States, and said about the 1944 decision, Korematsu versus United States was gravely wrong the day it was decided, has been overruled in the court of history, and has no place in law under the Constitution. But it did not actually overrule or set aside the U.S. Supreme Court decision in 1944, and in fact went on to use the basis of national security and concerns about potential terrorism invoked by the executive branch in order to support, by a 5-4 majority, the what have been referred to as the Muslim ban, a ban based on exclusion from the United States of individuals from particular countries that are recognized as having Muslim majorities. Today, this case is before you in the court of history, and it's been briefed by both attorneys for Fred Korematsu as well as by the United States. Fred Korematsu's attorneys have asked for oral argument, which you granted, and the United States government has decided not to present oral argument, but they will rely on their brief. The arguments made by Fred Korematsu's attorneys basically boil down to asking you, the court of history, to make a final determination that Korematsu versus United States was wrongly decided, that Executive Order 9066 and the wartime exclusion statutes that created the wartime exclusion zone that resulted in the essential deportation of over 110,000 Japanese Americans from their homes, their jobs, their schools, and their incarceration and removal their removal from the war exclusion zone and eventual incarceration was unconstitutional. As we just saw in the film, Judge Patel's decision in 1983, while it overturned the conviction of Fred Korematsu because of the finding of fraud, they could not find a way to overturn the holding of the U.S. Supreme Court that the incarceration was a legitimate exercise of executive power. The government has asserted that Korematsu, to the extent that it holds that the executive branch may, in a time of war, take action again that singles out particular groups of individuals because of their likelihood of engaging in sabotage or espionage, still stands, was properly invoked in Trump versus Hawaii, and that in Trump versus Hawaii, the reason why it stood was because there was a provisions for extreme vetting or investigation and determination of loyalties, which was lacking in Korematsu and in the incarceration of Japanese Americans. And they also rely on the case of In re Mitsuendo, which is a case that came down on the exact same day as Fred Korematsu's case in the U.S. Supreme Court. The U.S. Supreme Court granted a writ of habeas corpus, saying that Mitsuendo, who was conceitedly a loyal U.S. citizen of Japanese ancestry, could not be indefinitely incarcerated, and therefore essentially brought an end to the incarceration of Japanese Americans in the concentration camps, where those Japanese Americans were conceitedly loyal. And that decision came down the same day in 1944. The attorneys for Fred Korematsu argue that in their briefs, in their reply briefs, have argued that the case of Mitsue Endo and Fred Korematsu are not on opposite poles. What happened in Mitsue Endo's case was that the court never had to reach the issue of whether her initial removal and detention was appropriate. They were just simply dealing with whether her continued incarceration was appropriate, found that it was not, and also they rely on the fact that the government relies on the fact that Mitsue Endo complied with the removal and exclusion laws, whereas Fred Korematsu willfully did not. Fred Korematsu's attorneys say it really doesn't make a difference, that loyalty, citizenship should not have been the litmus test before people are removed from their homes. And that essentially summarizes the arguments that have been presented in the briefs. At this time, does the panel have any questions for the research attorney?
Do not. Very thorough.
Very thorough. Thank you very much, counsel.
Thank you. Well, then at this time, then we'll be proceeding to oral argument, and the attorneys for Mr. Korematsu, Mr. Perez, and Mr. Fu will be addressing you.
The court at this time will call the matter of Fred T. Korematsu on behalf of himself and 120,000 Japanese Americans versus the United States of America.
Can I just make sure my phone's on?
And before we begin, I do need to make a disclosure to the court, and that is as follows. Had this been a real trial and not a mock trial, I would have disqualified myself from hearing this matter because my family in San Jose was actually deported, detained, and sent to Hart Mountain Detention Camp during the war. They were my father's family. They were residents of San Jose. He, all his brothers and sisters, his parents, his grandparents were uprooted from here in San Jose. They left their home, their orchard properties, their business in a matter of 2 weeks, and were sent to the detention camp. All 5 actually of the brothers, my 4 brothers and my father, all served in the United States Army. That is how they got out of the camp, while at the same time all of their sisters, their parents, and their grandparents remained in the internment camp. An inconsistency, circumstance that I had great difficulty reconciling to this day. Unlike Karen Korematsu, this was a situation that I knew very well of as a small child, all the way growing up. It was something that I heard about, knew about very well, and I believe that it actually has contributed to the fabric that I carry with me to the court today. So with that disclosure, I would normally have recused myself from this case because it is a mock trial. I will remain on the bench here to hear this.
I'm weighing in my own mind whether, for the benefit of the audience, when a judge makes an individual determination as to whether to recuse, as the presiding justice of this court, I probably would have had a discussion with Judge Takaichi about whether that was appropriate in this case. I'm not sure you should be recusing, but all right. Thank you for informing us of all of that. So I will now go the case. Fred T. Korematsu on behalf of himself and 120,000 Japanese Americans versus the United States of America. I'm going to ask counsel to state your appearances first. Tell us your names.
My name is Eric Perez, and my co-counsel Chris Buna, representing the petitioner Fred Korematsu on behalf of himself and on behalf of 120,000 Japanese Americans who were interned during the Liberties.
Mr. Perez and Mr. Brew, typically argument is made from the podium. Is your argument organized in such a way that that would be appropriate, or do you both need to?
Your Honor, it is organized in such a way that we can speak individually.
Thank you.
Justices, may it please the court. My co-counsel Chris Boo will present the distinctions between Mitsue Endo and Fred Korematsu's cases and the mistaken position that loyalty is the litmus test for incarceration. I will be addressing the government's constitutional violations on the Equal Protection Clause and Due Process Clause. This court should reverse the Supreme Court of the United States decision because it was clouded by racial affinities and racial antagonisms. This court should find in favor of the petitioner for two main reasons. First, Executive Order 9066 and the subsequent exclusion acts violate the Constitution's 14th Amendment Equal Protection Clause. And second, the incarcerations that were implemented do not meet the procedural safeguards guaranteed by the 14th Amendment's Due Process Clause. First, on equal protection. The legislation that was passed because of Executive Order 9066 targeted people based on characteristics and qualities that they could not control, their race. By targeting all people with Japanese ancestry, the law reached out and attached the innocent bystander on a matter of circumstance they could not control.
So, counsel, if I might interrupt, which is typical in our argument, let me just ask you, the countervailing argument would relate to the government's compelling interest in the military situation at the time. Pearl Harbor had been bombed, the Japanese were antagonistic at that time. We were in a state of war with the Japanese. And so my question to you is, given the fact that the Pacific Fleet had been destroyed, and there were not a few, but tens of thousands of folks of Japanese descent living on the West Coast, are you suggesting that the United States government had no right and no authority, legal authority, to identify and screen persons who might pose a serious security threat to the interests of the nation at that time?
Your Honor, the government does have that right. The issue associated particularly here is that they didn't do it in a compelling and justifiable way. And also, along with that, the government did take actions before the implementation of Executive Order 9066. They rounded up key people who are part of the Japanese community, priests, and other people that are associated with high-level business organizations, and they questioned them to determine their loyalty. So the government did have the power and still have the means. What we're arguing here is that creating the Public Proclamation number 7 specifically that targeted a lot of more people generally who were not encompassed and were not even associated as threats, military threats, is unconstitutional on its face.
So let me ask you this question. In a sense, you are saying that the government's action violated the Constitution because it was, in a sense, under-inclusive. Let's assume that, as opposed to simply directing the 9066 to folks of Japanese ancestry, that folks of German and Italian ancestry had also been included. Would that, in your view, constitutionally remedy the violation that the government engaged in?
No, Your Honor.
Why is that?
It's because that would have helped alleviate the under-inclusivity issue associated with strict scrutiny, but it still would have it still would be targeting too many people on its face, because there were many people who would have been targeted simply based on an aspect of race who were not in any capacity military threats.
So, sort of going from what Justice Greenwood just was asking about, assuming that the court were to apply the strict scrutiny test to the constitutionality of Executive Order 9066. Would you not agree, counsel, that the Constitution assigns to the elected branches of our government 4 powers, and that the court has limited authority and competence in reviewing their decisions concerning matters military as well as national security?
Your Honor, yes, but when the War Powers Act, or when such legislation goes beyond the bounds and starts targeting individuals just based on matter of circumstance, the court has a duty in order to uphold the constitutional protections that are afforded to individuals and helpless people within the country.
And you talked briefly about the law being over-inclusive, and you said in general terms what that meant. But can you specify precisely why this law was over-inclusive in its application?
Yes, of course, Your Honor. The law was over-inclusive because it reached out to those people who were not at all deemed military threats. For example, it reached out to generations of people who were Japanese simply by birth. It targeted people up to 1/8 Japanese. There was no military necessity for that to occur. General John L. DeWitt indicated that racial affinities are not severed by migration, and these people who had been in America and had American citizenship were not, quote, Americanized.
And so you're also saying that it would also have applied to small children, disabled individuals, the elderly as well, as long as they had ancestry, Japanese ancestry?
Yes, Your Honor.
So recently the United States Supreme Court decided Trump versus Hawaii. Can you help us understand how you reconcile your position in this case with the Supreme Court's ruling?
Your Honor, we don't concede Trump versus Hawaii. We believe that the constitutional framework was wrongly decided there, or the constitutional issue was wrongly decided there. It still was clouded by racial targeting and racial fears towards people who are basically deemed other. If there is a distinction that can be drawn between that case and this case that we have right here, is the uniformity that's put in place. In the Korematsu decision, uniformity is essentially non-existent. In a place where the U.S. government has the most strategic the executive order and the public proclamation should have been applied in places where the U.S. government had the most strategic issues that could have arisen. For example, Hawaii was a strategic decision that could have been overtaken and could have been deemed a military risk, but yet these public proclamations weren't issued in Hawaii, and Hawaii had a large population of Japanese people, and it comes down to uniformity. It did not occur while the Trump versus Hawaii case does have uniformity.
Of course.
On that one point, the government has argued that Hawaii is distinguishable from the West Coast in that Hawaii was effectively taken out as a threat against the Japanese government because the Navy there was destroyed. So there was really no need to worry about any sort of land invasion or further attack on Hawaii. How do you respond to that government argument?
1 minute, counsel.
Your Honor, the difference is that even though there wasn't a chance of land invasion, there's still a chance of espionage to occur. So if the government truly did fear the potential for espionage, then they should have implemented some sort of executive order or some sort of relocation act in that position too, if they wanted to keep it uniform and they were actually fearful of espionage.
Just finally, because you have a short period of time left, let me ask you, would it have made a difference in your view if instead of simply issuing Executive Order 9066, the United States government, through military or some other established agency, had engaged in extreme vetting, the type that's described in Trump versus the United States, wasn't really available at that time, of course, more data, electronic capabilities than there are now, technological advances. But even in places like England, there was vetting done on an individual basis of joint nationals, for instance. So tell us how would that affect your position? Does it remedy the problem?
It could remedy the problem. However, the issue is that, one, that did not occur during World War II. And the vetting that's put in place during World War II would have looked very much different and would not have been able to necessarily occur at the same level that we have now in modern times. And so with that in mind, I think that there would have been a very different outlook and different way that vetting would have occurred. And so because technology has advanced so far and vetting processes can become better, I believe that the US government likely would not have been able to vet in a way that would have been permissible by the Constitution.
And of course, it still would have been based on race.
Yes, it still would have been based on race, Your Honor.
Thank you, counsel.
They could only live in the so-called relocation centers, which was not made for human habitation. There was no hearings when they were taken by bus and train to detention camps and they was told to stay there indefinitely. Furthermore, even when they were forced to pledge loyalty to the United States, they were told to stay, they were not released from the detention camp or the incarceration until the Supreme Court stated in Reed, Mitsui, Endo that it was unconstitutional. There is a material difference where when Germany and Italy also declared war against the United States, German and Italian Americans, although their loyalty was in suspicion, they were afforded individual hearings, whereas none of Japanese Americans were afforded hearing, and that disparate treatment showed that there was elements of racism behind the exclusion and mass detention of all Japanese American citizens down to 1/8 of the blood.
So counsel, you're inferring from your argument that the means that were chosen to accomplish the alleged compelling interest of protection against espionage, possible land attack on the West Coast, the means to accomplish that goal, I believe you're arguing was not rational or reasonable to accomplish that goal, and that there was something, in other words, it wasn't narrowly tailored to accomplish that goal. What else could have been done in terms of achieving that goal without violating the Constitution?
So as Mr. Burris was kind of touching on, what should have been done was hearings should have been done in the first place before even having been told to selling their homes and possessions.
What about the government's argument that it was impractical to do that with 110,000 people? We were in the middle of a war, something drastic had happened at Pearl Harbor. The cost of doing that and the practicalities of administering that number of hearings were insurmountable. How would you respond to that argument?
So even though in times of war and crisis and that the government, such as the executive and the legislative branch through Congress, have the authority to declare certain of military necessity and that certain civil rights may have to be pared down, they still have to ensure that the fundamental constitutional rights are not just automatically taken away due to fears and concerns based on prejudice or fear related to race. And furthermore, at the time in England, when they were concerned about espionage or sabotage from German nationals, there was 100,000 similar amount of numbers, but they were able to administer hearings based on a mass amount of similar populations. related to like the concerns of national security during the European theater of World War II. And so
That did not require any detentions.
that did not require any detention without a hearing, which the U.S. Constitution says, due process is afforded to all individuals. The government cannot take that away, especially when it comes to like property and liberty, which happened because, they were, told to like sell their business and their homes, and their freedom was stripped when they were indefinitely detained in isolation and detention centers without the right to a hearing. And so, furthermore, loyalty should not be a question saying, loyalty should not be the litmus test to whether they are afforded the right to a due process hearing. There's no distinction between our client Korematsu's case and Ms. Mitsuye Endo's case because they came from the same core common facts where even though for Endo the Supreme Court narrowed it to the facts of the indefinite detention was unconstitutional, for Ms. Endo, she still went through the whole process of having to leave her job, leave her home without due hearing. We're still taken to a relocation center before being ordered to be sent to a camp in Topaz, Utah. Like, what Mr. Korematsu is not arguing is about, there's a difference where, my will to non-comply to the U.S. law saying like I have to turn myself into the relocation center. What we're arguing is that from the very beginning, Executive Order 906 says, and the ensuing exclusion orders and proclamations were unconstitutional because there was no due process.
So let me ask you this question. If the group had been narrowed, let's assume that 9066 had been written so that it was directed towards not all persons of Japanese ancestry, but to a much more narrow group, for instance, those who were not American citizens. What would be your position?
There's an issue still with that because in the time of World War II, first generation Japanese in America were not allowed to naturalize to become U.S. citizens.
So involuntary on their part, they were precluded from citizenship.
Correct, Your Honor, and based on that, it was fallacious to assume that those non-citizens who were born in Japan, to assume that they refused to disassociate from the loyalty and based on to the Japanese emperor at the time. It was not because it's not that they decided that they want to remain loyal to Japan and that's why they did not disinherit the Japanese citizenship. They were just not afforded the choice to become citizens of the U.S. through the naturalization process. They were not given that choice until long after World War II. So the non-citizenship concerns is even still there's no compelling and legitimate interest why the U.S. military decided that, especially non-citizens, there's concern that they are spies or spies of the Japan Empire and will sabotage U.S. national security.
Counsel, do you believe that Trump versus Hawaii is overruled United States versus Korematsu? And if not, why not? And how does it remain today as well?
We say that the Korematsu versus United States was not overruled. The Supreme Court of today, they did not go to say which part was overruled. They just say this court of history, which, as we are now in the court of history, it is urgent that the courts overrule what Korematsu United States say, because we cannot go on to say that even in times of national crisis to the threats to the borders that we can deny constitutional rights to a particular class of certain race or national origin. Thank you, Your Honor.
Thank you.
Thank you.
I
At this time, is the court going to confer about their decision?
Yes, we will. I believe we're meeting and conferring through microphones, however, is that correct?
Correct.
That's what I thought. So, Justice Gogo, what's your thought? Let's have a chat.
The court sitting today has the luxury of having all the information that's been developed over the years in the case. I'm not limited to the information that was just presented to the Supreme Court back during the Korematsu decision. We're also afforded the luxury of not having been appointed by Franklin Roosevelt to the bench. And at that time, President Roosevelt was a very popular president. Also, the level of hysteria in the United States from the war couldn't be any higher than it was. Not only that, the publications, journals, newspapers were publishing some very shall I say, Japanese sentiments. On another program, I shared some of those statements, and if I can find them, I wanted to share one with you, just to give you a flavor of what was being said back in those days. This came from a California newspaper, none less the Los Angeles Times, and they said the following, quote, "A viper is nonetheless a viper wherever the egg is hatched. So a Japanese American born of Japanese parents, nurtured upon Japanese traditions, living in a transplanted Japanese atmosphere, notwithstanding his nominal brand of accidental citizenship, almost inevitably, and with the rarest exceptions, grows up to be a Japanese and not an American. Thus, while it might cause injustice to a few to treat them all as potential enemies, I cannot escape the conclusion that such treatment should be accorded to each and all of them while we are at war with their race." So, I mean, that was a sample of the sentiment that was being published in our national newspapers. So, we today don't have that type of pressure, that type of influence imposed on us, and we are in a better position to more objectively view the evidence and the arguments presented to us.
Now, if I can add to that, Judge Takichi, I think as the court of history that we are today, we also are much different in terms of diversity compared to the court back in 1941, 42, 43, 44. So I think we bring different perspectives to this issue that's being litigated before us as well. And I think that's important too, because as you talked about your family being directly affected by the incarcerations and the relocations, I also come from a family that served in the military too. And so while I understand the importance of giving support to our military, I also now understand, more importantly, preserving our individual freedoms and the protection of our laws, protection of our individual liberties through the due process clause. And so, again, I think that's important to factor into our discussion as well.
So I would suggest, where I am leaning on this, find that, first of all, the Executive Order 9066 is subject to the strict scrutiny test, which requires a finding of a compelling government interest. Inasmuch as the evidence that we have since learned about was withheld from the court at that time, as well as inaccurate, as well as overstated and exaggerated, I cannot find that the government proved a compelling interest that would support the constitutionality of Executive Order 9066. Even assuming there had been a compelling interest shown, the means
adopted to deploy and to accomplish the purpose of land invasion, espionage, even if there had been an adequate showing of that, to me, was not the least restrictive available. We heard from counsel, we've heard from in history that other countries like England were able to conduct pre-detention hearings of their enemies at war, suspected non-loyal individuals from Germany or Italy, and they conducted, I heard from argument, 60 to 100,000 of those interviews without having to incarcerate individuals. So I think there was a means available less restrictive. I'm not buying the government's argument that it was too expensive, too burdensome for them to undertake that process, because I suspect the cost to the government of rounding up 110,000 people on the West Coast, shipping them to detention camps, building even these substandard housing, and then sustaining that through the course of war probably dwarfed the amount of expense that the government would have otherwise incurred just conducting hearings, not for all 110,000 people, but for those realistically suspected of perhaps causing some concern to the U.S. government. We can eliminate all the children, eliminate all the elderly. There's plenty of loyal citizens that their loyalty was unquestioned. United States citizens, do we even question them? So I don't find the means was the least restrictive available to the government, and for those two reasons I would find the executive order and the resolutions that followed after that all to be unconstitutional and unenforceable.
I agree with you, Judge Takeuchi. I think I would also add that there was an equal protection argument raised, and one of the things that we learn as judges, one of the canons that we must observe is courage. To take unpopular positions when the rest of the state or the country is leaning in a particular direction, because they're afraid. And that's when courts really have the obligation to step up. The equal protection argument, I think, is important here because as much as we do not want to believe this about our country, there has been a long history of racism. There's absolutely no question that the evidence supports the fact that there was an equal protection violation here because people were targeted because of their Japanese ancestry. That's the only reason they were targeted. That Germans and others who also posed a danger to the United States at the time, we had people fighting at the time against Germans and Italians and others, is an indication that people were being targeted based on race. And now I think we probably would all agree, I hope, that people of Japanese ancestry are not the target now in the United States, but there are other targets, as we know, and there will continue to be targets. It is why we have the Equal Protection Clause in the United States in our Constitution, because the reality is human nature can be tribal, and our Constitution fights against that. So I would say that I would vote with you, but I would also add a vote that there was an equal protection violation here, and that 9066 cannot stand because of that, and that the Korematsu case should be overturned and deemed a violation of constitutional law. And an unfortunate decision from some justices, actually, who I really admire. in other parts of their jurisprudence, they did amazing things. And I'm just going to say, Felix Frankfurter, there's such an irony about him in particular because he was Jewish. And it was known that they were putting Jews in concentration camps in Europe at that time, but somehow he couldn't make it. I don't know if he could make the distinction or he saw it differently. I'm not sure exactly what it was, but anyway, that's what I would think. What do you think?
As some of you in the audience can see just from where you're seated, I'm the newest justice on this bench, and as the newest justice, obviously I forgot my robe.
He can be caught, however.
And I took very detailed notes because I was prepared to ask questions of the attorneys, but my two esteemed, experienced colleagues beat me to the questions every time, and I didn't want to ask a redundant question, so I apologize to the young lawyers here who were very prepared. We went over your briefs, and yes, let's get a hand in that. Move our program along. I endorse the reasoning and rationale by both Judge Takeichi and Justice Greenberg and Greenwood. I'm sorry, Greenwood. And I would also vote to join you in overturning the case of Korematsu versus the United States.
I'm told that I'm also supposed to designate the justice who will write the opinion and so that's it. No. How about you've got some great briefs to work on. Thank you very much.
Thank you to our justices. Appreciate it very much. Yeah, you volunteered your time to come out here.
The justices are on the bench there. You talked about courage, and I want you to know that Justice Robert Jackson and Justice Frank Murphy were both appointed by Franklin D. Roosevelt. So that took courage for them to, submit their dissenting opinions. Also, I want you to know that because the government and the military learned that the Endo case was going to be heard, even though it was heard on the same day of my father's case, and sometimes, after I learned about my father, and talk about this later, but I would read Endo Korematsu case, and I thought, what's that? But it's because those two cases were heard at the same time. But the 2 days before, the government announced that the incarceration camps were going to be closed, and that's why Endo became moot.
Thank you. At this time, I'm going to ask Karen Korematsu and Professor Russell, and so that you all can see them more easily. Oh, you can sit on the bench. Come on up.
My name is Margaret Russell again, and at first I'm especially grateful to see all these people here, all of you, on a Saturday morning through afternoon, and the judges and law students who, believe me, never have a free moment, contributing all the effort to make this a special event for us. Very educational. Thank you to our advocates, thank you to our judges. I'd also like to just tell you that pretty soon we're going to give you a chance to ask questions and make comments. But first, I am very delighted to introduce you to Karen Korematsu, daughter of Fred and Catherine Korematsu is how I met her many years ago, but she obviously is a very complex and wonderful person in her own right. And she's going to speak first, then I'll speak, and then we'll open up to Q&A.
Is it afternoon now? Good afternoon. I'm thrilled. So many people. This is exciting. And of course, some of you now, are there any high school students here? Oh my gosh, you must have, wait, would you get an assignment or something that you have to know? Are you studying U.S. history at this time, I assume? That's why you're here? Yes. Which high school?
Santa Teresa High School.
Sorry, say again?
Santa Teresa High School.
Oh, Santa Teresa High School. Wow. Is that near here or?
No.
San Jose. All right. Well, is the teacher here with you? No? Of course. Okay, I'm gonna find out who your teacher is because I'm really quite impressed. And the reason I do this actually is for you. You know, your generation and future generations, because obviously we have not learned our lessons of history, that we keep repeating them. And I'm glad that you're studying about this case, but it goes beyond that, because it's the relevancy of what Korematsu means now. Because, you know, our democracy is still on attack. And you all need to know what your rights are. That's, you know, my father learned about the Constitution in high school. That was in 10th grade at Castlemont High School in Oakland, California, and he was paying attention that day. And so, because later on, he thought he had rights as an American citizen. Why would he have to be put into a prison camp when he had done nothing wrong, right? That's what we were talking about. Due process of law was totally denied. There weren't any charges. No one had access to an attorney. No one had their day in court. And as we talked about, there were no hearings. And so that was a complete violation of our rights, because, you know, 2/3, and we talk about, it's interesting because we've heard this number, and I want to be clear, 110,000 to 120,000. You know, the government wasn't very good about keeping records, let me tell you, but that's not a surprise. But ultimately, there were 120,000 people of Japanese ancestry that were incarcerated. 2/3 were American citizens, and 1/3 were under the age of 18. And if you were only 1/8 of Japanese ancestry, then you were put into this, you know, into the prison camps. So, and it didn't matter if you were a baby or if you were ill or in a hospital. They pulled you out. They sent you to these prison camps. And first we saw the ones in Tanforan, the Bay Area, Santa Anita. If there weren't racetracks, independent ones, they found horse stalls on fairgrounds. And then they put them into some sports centers up and down the West Coast. And also, I want you to know, especially, that there was also a Canadian incarceration. There was about 20,000 Canadian Japanese that were put in prison camps up there and then really sent off to work camps. Also, the Japanese from South America were kidnapped by our government and put into prison camps like Crystal City, Texas. And those people have never, the Japanese, Latins, and the Peruvians have never been totally apologized to from our government or even compensated with reparations. So this was certainly an international violation of human rights. And that's one thing I want you to remember. Human rights were violated, not only our own due process. Also, I wanted to kind of plug my father's documentary, and because we're working on a high definition. We received a grant through the California Civil Liberties Fund to develop a high definition and 4K that's going to be able to be broadcasted even on Netflix. But it received 2 Emmys. So it was an Emmy award-winning film, and my mother gave my father the charge, my mother gave my brother the charge to make a documentary. This is around 1990, and everyone, you know, was trying to make documentaries about their families. Before iPhones, you know, on real film, but it took 10 years, you know, to complete. And halfway through, people didn't think my brother was going to, you know, could tell a true story about my own father, or our own father. Then he brought in another film director, Eric Paul Fournier, and so it received 2 Emmys in 2002. So, and also I wanted to note for the attorneys that are the law students that are here, that the legal team that you saw talking, Dale Manami, who was the lead counsel, and Don Tamaki, there's about a core of 10 attorneys, and then people that did the research from coast to coast, even as far as New York. And they worked pro bono, meaning that the first time I met these young people in my parents' living room in 1982, and I heard my father turn to Professor Peter Irons and said, "Gee, these kids look like high school kids. Are you sure they know what they're doing?" And Peter said, "Yes, Fred, they're really, really smart." And also, many of them, not all of them were Japanese Americans, but because they wanted their own families to be vindicated as well. And that was really important. But they worked, nights and weekends and on this case for no money at all. And that really says a lot about their integrity and their courage, because they could have lost Korematsu versus the United States all over again, and what would have happened to their careers? So that was a big risk. Am I talking too long? Okay. If it wasn't clear, the outcome of my father's quorum nobis case, and for law students here, the legal term is writ of error petition quorum nobis. Quorum nobis is a Latin term, means that error has been made before us, and error has been made before the court. So because my father and Gordon Hirabayashi and Menyasui, who were the other two Supreme Court cases, they had to do with curfew. My father disobeyed the military order outright. The outcome was governmental misconduct. If you don't remember anything else, remember governmental misconduct, because this seems like this is what we're continually learning. And also, I signed on to an amicus brief. For some of you that don't know, amicus brief means friends of the court. So it was a brief that I signed on to. I've done about 5 now for different cases, and this last one was Trump versus Hawaii, along with Holly Yasui, Menyasui's daughter, and Jay Hirabayashi, Gordon Hirabayashi's son. And the point that we wanted to make was we wanted to remind the court of my father's Supreme Court case, because it's always kind of thrown around. It's kind of funny about Korematsu this, Korematsu that. That's my name. That's the point. Was we wanted to remind the court, the Supreme Court, of my father's case and the dangers of the overreaching of power. Sound familiar today? And the checks and balances that we need to keep reminding the courts and our government to uphold, because clearly that's what's being violated. So here we are over 75 years later, because while my father's, actually the 75th anniversary of Korematsu versus United States was December 18th, 2019, last year, just a month ago, right? Here we are, 75 years later. What has changed? So, when Chief Justice Roberts decided to kind of, what I say, and I can say this, I've been told by the National Judicial College, just in case you want to know, the opinions, there were 6 majority opinions in Trump versus Hawaii. No, I'm sorry, 5 majority opinions in Trump versus Hawaii and 4 dissenting. And the dissenting opinions was, one of them was Justice Sotomayor. And she wrote, if you want to read an interesting opinions, and that's one thing you learn in law school is writing. And for even young, you people in high school, and learning writing skills is so important. And it was my brother and I and our family felt like it was kind of a throwaway act by Justice Roberts to say that, quote, he overruled, because that is the question. What exactly did he overrule in Korematsu versus United States? I speak to lots of constitutional scholars. Neil Katyal, who is a former Solicitor General, is the one that really argued the case in front of the Supreme Court and represented Hawaii. I was sitting in that Supreme Court that day. If you ever want an interesting experience, go sit in the Supreme Court during oral argument. It's interesting because the justices kind of just speak over each other. Really, quite an experience. But I learned, you could tell by the questions that were being asked and the questions that were not being asked, possibly the way that opinion was going to go. And even for amongst these constitutional scholars, that it is pretty gray as far as what did Justice Roberts overrule. So when you read something, and you can't always believe everything that you read, you do have to check your facts. That's the important thing, is to check your facts. But I want to read to you what Justice Sotomayor, just a brief paragraph of the ending of her dissent, because I think it's very, by blindly, I quote, by blindly accepting the government's misguided invitation to sanction a discriminatory policy motivated by animosity toward a disfavored group, all in the name of a superficial claim of national security, the court redeploys the same dangerous logic underlining Korematsu and merely replaces one gravely wrong decision with another. Our Constitution demands, our country deserves, a judiciary willing to hold the coordinate branches to account when they defy our most sacred legal commitments. Because the court's decision today has failed in that respect, with profound regret, I dissent. Usually she says, I respectfully dissent. She just said, I dissent. I was fortunate to meet her a year ago, and she's such a dynamic person. But you know, these are very strong words and a reminder that we need to keep fighting for our democracy, to keep challenging when we think the government is wrong. And the one thing also that I want to say is our equal protection under the law is so important. And we want to remember that that's what we need to uphold. Thank you.
I'm sitting here happily hoping that you talk for, and in fact, I'm actually very grateful that because of some of the points that you covered, my talking time is cut in half because you said it so well, including Justice Sotomayor's language from Trump versus Hawaii. A couple of things before I make some brief comments and then open it up for questions, because we actually have about 20 minutes or so for the rest of the program. First, I wanted to ask the students who argued, and you saw the backs of their heads, to stand up and introduce themselves, if you might, just to say your names and what class you are and a little bit about how you got interested in this. And please turn around so that people can see the front of you.
Hi. So once again, my name is Chris Wu. I'm currently a second year, or in law school we say like going up to I'm a 2L. So yeah, my interest is related to civil rights. I'm interested in disability rights and mental health. I wanted to do this because I think one of the reasons why I wanted to go to law school and become a lawyer is like I wanted to do like civic participation, fight for civic rights, and I said education is one of the important things, and I think like giving like factual and legal education is part of my duty as a law student and a future lawyer. So that's a big reason why I wanted to do it. And also in times of current events, I was like, I just got to do something about it, so it's one way I can meaningfully participate.
I'm Eric Perez, and I'm a first year, so 1L. For very much the same reason that Chris talked about, I'm joining this project. I think it'd be good exposure and good opportunity for writing and to hone my writing skills. This is definitely outside the normal scope of what first year law students do. Yeah, that's kind of the reason. Also, I wanted a chance to really be a part of something that's bigger than myself. As a minority, a person of color, I have a lot of qualms with what the government's currently doing right now. So I kind of wanted to get my anger out, I guess, in a controlled manner. So yeah, that's it.
I am very inspired by your work. When Judge Hayashi called me months ago with the idea for this argument in the court of history mock trial, in all my years in law, I've never actually participated in a Korematsu connected mock trial in the court of history and oral arguments. And I think it's a brilliant idea, and you did a brilliant job with it. And I thank you for taking the time. And if there are any attorneys in the audience, job offers, please, whenever they're finished with their studies. I also wanted to just say a couple of things, I guess on 3 quick levels. One, I guess I'll just start with my connection to Fred Korematsu and Catherine Korematsu and Karen Korematsu, which started in the late 1980s, I believe. I was very involved. I started my legal career getting involved with the ACLU of Northern California, which from the movie that you saw was actually the only part of the whole national organization of the ACLU that was willing to challenge the Japanese-American internment. And I emphasize that because this year is the 100th anniversary of the National American Civil Liberties Union. And it's been probably for, since the Korematsu case, a real subject of discussion that even what was the bravest civil liberties union, civil liberties organization in the country at the time, it still took just one tiny part of it to say, we're going to take this on. And the rest of the ACLU, the National ACLU, was really saying, we're friends with President Roosevelt. And so it just shows you how vigilant we all have to be to do our own thinking and deciding, because even, great civil rights advocates, and as several of you have mentioned, very legendary civil liberties champions on the bench, they just fell down on the job. They just looked the other way, and that's horrifying. So I wanted to mention that in the ACLU of Northern California, Fred Korematsu had long been a hero. We certainly knew about and were linked to the 1980s overturning of his conviction by the young attorneys in Northern California. But Fred Korematsu and Catherine Korematsu, and now for a long time Karen, they live the case. They live the legacy of the case. Fred Korematsu was out there, coming to ACLU events, coming to civil rights events, marching with students. I had the opportunity to get to know your parents, and I thought they were actually delightfully humorous, funny. They had great senses of humor. And, Fred was already, what I considered at the time, very elderly. Now that I'm older, I don't think of it that way. And they were my heroes, right? Not law heroes, so to speak, but civil rights advocate heroes who had suffered, who had stood up, and who actually continued to stand up for every generation. And if they were alive, they'd be right here, so happy to see the young students. They lived that. So I wanted to mention that, and I had the chance to get to know the Korematsus toward, for the ends of their lives, and that was a great honor. Another personal note that I want to make, and it's really came up when there was a brief discussion of, this whole idea of Japanese ancestry being the basis for Executive Order 9066, and a couple of years ago, I decided to get ancestry DNA swap. I don't know if anybody ever knows how you do that, but you put a little saliva slab and send it in. And I already knew who my biological parents were, so that was not the mystery. But my mother was a first-generation Japanese American who came here in 1952. So after this period, and was living in Yokohama when she met my African-American dad, who was in the United States Army. So when the judge talked about the Army, and then you talked about your legacy, I kind of had it both in my family. They met, they married, they had my oldest sister. They came here, and the U.S. in the 1950s onward was really, rife with bigotry for both of their races. So part of my growing up and growing into adulthood has really been to realize that the people who came before me directly suffered racism and racial discrimination. And so when my ancestry DNA came back and it said 50% Japanese, and you mentioned this today, I thought, so what was the government going to do? Like, give swabs to people? Or no, but what they did was what we now realize is racial profiling. You look around. Can you imagine a society in which we are encouraged to go to school, to go to work, to walk around the street, and to see each other as potential enemies because of the color of their skin, because of their features, because of the language they're speaking? It is directly related, I think, to the hatred and the rise of hate in the United States today. So every time you give us a chance to honor Fred Korematsu through Fred Korematsu Day or through a discussion of these issues of what it actually means to single out a category of people based on race, based on ancestry, ethnicity, and to say, without any individual decision-making, without any individual questions about whether or not that person is disloyal, you're just going to assume that's the enemy race. So I see a lot of lingering aspects of that today as well. Finally, before I turn it over just for some comments from the audience and questions, I want to mention that at Santa Clara University, we are actually having a number of events even beyond this month that I think are very relevant to this. I have a colleague from Art and Art History, Renee Billingsley. Yes, and Renee Billingsley, Professor Billingsley has an exhibit starting on February 8th going through April 19th at the Triton Museum of Art in San Jose called 10 Japanese American Concentration Camps. There are some cards out there. There's an opening reception, and the photography and just the aesthetic eye and the awareness of history is really incredible. Secondly, the U.S. Holocaust Museum, based in D.C., reached out to us, and we are partnering with them in an event February 19th and 20th that actually directly focuses on the Nazi Germany concentration camps and Japanese internment camps. It's called Representations of Persecution in Nazi Germany and Northern California. And it's a several-day event with people from different disciplines and a discussion of what underlies the idea, right, of incarceration, of incarcerating people based on their race, based on their religion. So I hope you'll also come to some of that. And with that, I think we are moving into questions and comments. Yes.
I just want to make a clarification, because you talked about it in your presentation for the attorneys, or someone asked a question. After the bombing of Pearl Harbor, there were about 2,000 Japanese nationals rounded up, right? So that's what, like even J. Edgar Hoover, who said, we already know who the suspects are. There is no reason for the Japanese American incarceration. And that kind of, that time is what really is referred to as internment. Because you'll hear both internment and incarceration. So that was the start of that. Just like after 9/11, when there was another 2,000 or more Muslims that were rounded up as well. And then the incarceration is really what we refer to the 10 in prison camps that were and the forced the mass forced removal of Japanese Americans. And then the euphemisms of the one thing that was used, which I really kind of hate, I mean even Peter Irons used it, was evacuation. Because I can ask 5-year-olds, what does evacuation mean? And they know, like in California, it's like duck and cover because of an earthquake. Or you've got shootings all over the place. But that's to protect yourselves, from danger. And so people were forcibly removed from their homes, and that's what you wanted to remember. Also, I would be remiss if I did not introduce some of my family. My cousin Joanne, Korematsu, Karaoke, and her wife Jeff came over from San Ramon, right? My cousin and Uncle, my father's youngest brother, Uncle Joe, was Joanne's father. Then Gary Korematsu is my father's second oldest. His father was the second oldest brother, Uncle Harry, and his son Alan Korematsu, who you can see is young, and I'm going to be grooming him to carry on my father's legacy because I don't have any children and my brother doesn't have any children. So, you know, he's it. No pressure there. But he's a scientist.
So, well, I was going to introduce myself, but I guess that's already happened. I just wanted to touch on something that Karen brought up briefly, and that was tribalism, and it's something that I think that is a real big problem that this country needs to kind of face and try to overcome. And what I see is like all these problems with the internment and what's happening now. It's based off of our culture. You know, we wouldn't have put Japanese Americans into camps if there wasn't a culture of anti-Japanese sentiment in the United States. It wasn't something that just happened out of the ground. There was many years of not only Japanese legislation, but Chinese and other Asian races. You know, the Alien Exclusion Act, the property law as well. And so, in order to I think to stop these kind of things from happening, is to have a shift in that culture, a shift in the general change of everybody's attitudes, and not just focus on, oh, we need to make governmental changes. And but I see that this tribalism is causing this real big problem in trying to have this cultural change. We have these inventions like the internet and social media that I think, you know, does a lot of good, but at the same time also has its bad sides. People surround themselves in, you know, information and people that already agree with their thoughts, and that causes also them to not quite demonize, but to otherize the other side, saying like, how could this other side, you know, be thinking like this? You know, everyone around me thinks completely different. These other people must be, you know, they must be evil or something. And I think that's something that we really need to overcome and come together as a country. And I just wanted to maybe go ask Karen, like, well, what do you think that we could do to reach out to other people that have these like really varying opinions, and to we could we could go out, we could protest, we could vote, but I'm more like talking about what can we do for a cultural societal change. What do you think?
Good question. Thank you, and that is a good point, because ignorance is prejudice, and people are afraid of what they don't know. So unless we get to know those, like especially for the Muslim community, people are afraid of them. I mean, this is a religion. Kind of religious profiling in the making here. And especially for like high school groups, for college groups, even communities, that we have events to make sure that you reach out to those other organizations. So if it's if you're doing an Asian American event, and invite the African American organizations, or Latino, or LGBTQ, because that's how we learn from each other. Having and getting together and doing events that, let's say, a film event. I can tell you, if you do food events, boy, they'll come. It's not just for starving students. It's for our public. I mean, even I know that for the churches, that now more churches are trying to share events to reach out to those communities, to have people come and speak. For your schools, you want to have, the high school kids have come here, but, perhaps get people from the Latino community, African American community. I mean, it's Cesar Chavez Day, Rosa Parks, Martin Luther King Jr. Those are the opportunities. We have, the Mexican Heritage Month and Asian American, API months, to share those kinds of events together, because that's how we're going to, try to make some change. And Alan's right about kind of the tribalism that has really been our history since the day of our Native American friends. And it's something that we need to be aware of and not be afraid of. And also not to be afraid to talk about it, because that's, people are kind of, oh, well, I don't want to talk about that. They're not comfortable in kind of sharing their opinions. And ask questions. Or, when you, for you young people, if you don't know your own story of how your ancestors came to this country, go home and ask or do research. And find out, because in order to appreciate other people's stories and struggles, you need to know your own, and so that you can share that, so that you whether on the football field or basketball or in a debate team, those are the kinds of times when you wanted to share your heritage, because that's what makes America great. Is our diversity, but we need to have inclusion. Diversity and inclusion. If you don't remember anything else, remember diversity and inclusion. And what can you do when you leave here to make that kind of change?
Thank you, Karen. And thank you, Karen. There's two other thoughts I would like to leave you with. First is the Santa Clara County Civil Grand Jury is doing recruitment right now. And you want to know what you can do in this community or in your other communities, is there is a flyer out on the desk out there. Please consider applying for the Santa Clara County Grand Jury, and even if you're not old enough, please consider talking about your family members about applying. Yes, it is a big time commitment. It is hours a week for probably the civil grand jury may look at as many as 50 to 60 cases in a single year.
Wow.
But if you want to talk about getting involved in the community and providing a diverse presence, a cultural diversity, age diversity, it is one of the most impactful things that you can do. So please consider the grand jury. Another thing, and if you didn't get the theme from what Judge Gogo said, I'm going to reiterate it. That is the importance of having a diverse bench that reflects our community. And so we are, in Santa Clara County, our Superior Court bench is now, we have gender equality. There are an equal women as men on that bench.
Wow.
There is now, there are now every aspect of our community is represented in terms of ethnic and national origin diversity on our bench. But that's not typical of the United States. And so I want to say it is so important for those of you who are law students, who are thinking of careers in the law, to really think about going into public service. Prosecutors, defense attorneys. Justice Greenwood was the public defender of this county before she took the bench. Johnny Gogo was a member of our district attorney's office, and he was a community prosecutor before he took this bench. Their presence in the community as lawyers and ultimately as judges has helped make this community and the legal community a bench where we do have diversity, but it's really important that we continue to pursue that. So, thank you.
just kind of closing words of my father. Stand up for what is right, and when you see something wrong, don't be afraid to speak up. Thank you.